In March of this year, the practice focused on character and fitness in the legal profession. Fundamentally, character and fitness as a prerequisite to the admission to practice law throughout each of the states in the United States. We looked at its application, we looked at its origin, and we looked at the associated tensions that are relevant to character and fitness as an application in the legal profession. We looked at its original origins in this country, the 18th, 19th, and 20th century, its development throughout the states and with the development of our legal institutions, our law schools. We looked at how practitioners were impacted by the character and fitness examination and the prerequisite and the application. We looked at the tensions associated with the application. We also interviewed several individuals. We interviewed the commissioner and executive director of the Massachusetts Board of Bar Examiners and a commissioner on the medical licensing board for the Commonwealth of Massachusetts. And fundamentally, we didn't ask the question of why or why not should there be a character and fitness application. We wanted to start a discussion about character and fitness, to look at its various applications throughout the states and its applications by the various judiciaries. We wanted to explore how these applications came about. How did the questionnaires come about? How were they applied? How were they inconsistent, or how were they the same? And how are they evolving throughout the country in our history, and where are they going? So in doing that, we discovered that there were three major tensions that we tried to highlight in this issue. One was the lack of clarity generally with respect to the character and fitness application throughout the country. The second was a lack of transparency, a lack of consistency among the states, and a lack of uniformity as the application was actually delivered, completed, and viewed by the various judiciaries and the bar examiners. And finally, what is and what continues to be the underlying purpose for character and fitness in this country? As we began to discuss and review and examine character and fitness in the legal profession, we focused on one of the earlier tensions we uncovered as we were examining this topic: lack of clarity. What counts as a criterion in assessing character and fitness in the modern legal profession in the United States? Should mental health, for example, be an issue, or one's financial management or well-being be considered by a state or a judiciary in reviewing one's application for admission to the bar? Should one's activity on social media be subject to review, as is in the case in the state of Florida? What about a more affirmative attribute? Why should we look at a person's leadership in community service in any given community or state or commonwealth? And we should really consider how this criteria is applied and is utilized throughout the states. Because what we found was not every state is the same, and not every state looks at the criteria giving to it the same weight. And so that creates conflict and lack of clarity of students and individuals seeking admission to the bar in the various states of these United States. The second tension that we discovered as we were examining character and fitness in the legal profession was this lack of transparency, this lack of consistency, and lack of uniformity throughout our country. Assuming there is a clear understanding of what we believe today to be character and fitness, there's a lack of transparency about these rules. For example, in 2018, there were only 13 states in the United States that actually codified character and fitness standards. They were often applied inconsistently from one state to another without any uniformity, and within each state, some states applied different factors within the criteria differently with respect to individual candidates. So across jurisdictions and across states and across commonwealths, there is no clear uniformity and there's no clear predictability as to how an applicant might be treated from one state to another, which might otherwise encourage form shopping for admission to the bar. This lack of clarity and lack of uniformity across states undermines, I think, and we think, the very purpose of the character and fitness test and why it is utilized by the various states of our country, to protect the public and to try to create an ideal by which we can measure all individuals seeking for admission to the legal profession. The third tension we reviewed was the underlying purpose of character and fitness. Does the character and fitness requirement actually get at something? Does it create a predictor of trustworthiness of a legal practitioner across jurisdictions. What we discovered, in fact, was there's only a small group of individuals that have ever even been barred from the admission to the practice of law as a result of how they completed a character and fitness application. Ultimately, the review and confirmation, we were unable to determine whether it's a predictor of future behavior of a legal practitioner. So it begs the question at the end, what is the actual purpose of the character and fitness application across our country? In this issue, we also, as we have done in the past with the practice, we looked at character and fitness from a comparative angle, looking at how it is applied both in the United States and actually in the Canadian legal profession. And analogously, we looked at the other professions like the medical profession. And so we continue the tradition in the practice when we examine a subject to try to introduce the comparative analysis of the lead story with other significant issues related to that story. Finally, in this issue, we interviewed two very interesting and outstanding individuals in the legal profession who are both practitioners and scholars. We interviewed Jonathan Lippman, who was the former Chief Justice of the New York State Court of Appeals, and Sean Hopwood, currently a professor at Georgetown Law School, who's an advocate for a review of the character and fitness standards throughout the United States. We're very proud of this issue, and we hope that you enjoyed it, and we'll continue to examine this subject matter.